Good afternoon. You can be seated. The matter now before the court is Cumberland 24-574, State of Maine versus Thomas Coffill, or Coffill, I'm not sure what it is. Perhaps counsel will let me know. We are being streamed on the web, both by video and audio. And if counsel would identify yourselves by saying your names for the record together with the party you represent, starting with that appellant.
Sanders Womack for defendant Thomas Coffill.
Kristen Hughes for the State of Maine.
Thank you. And Attorney Womack, if you are ready to proceed, we'd be happy to hear your argument this afternoon.
Good afternoon, and may it please the court. This case presents two issues for appeal. The first is what constitutes sufficient evidence to convict a motor vehicle driver use of a dangerous weapon. The second is whether there was jurisdiction for this indictment and then Coffill's conviction. Now, past cases of this court and the legislative history of the reckless conduct statute both indicate that merely driving recklessly is not sufficient to constitute using a motor vehicle as a dangerous weapon. Looking at the language of these statutes and the case law indicates that for a driver to be convicted, the incident must occur in the context of an attack. And indeed, it makes no sense for in the context of cards or other things not designed as weapons to talk about them as their use as weapons outside the context of an attack. Now, it is well established that intent does not matter. Intent is not an element. At the same time, the context matters, the circumstances matters, and the motivations of the defendant matter as to whether the defendant used the motor vehicle as a dangerous weapon. Consider the two sufficiency cases we have from the law court, State v. Jones and State v. York. State v. Jones, the defendant pulls up alongside another motor vehicle, yells threats at the occupants, attempts to prevent them from leaving with his car, then chases them down, and at a high rate of speed, turns his car into the other, causes a collision, and forces that car into a ditch. That is sufficient evidence that he had used his motor vehicle in an attack. State v. York,
I see that the green light is on. Can you say in one sentence, give me the holding? What separates, as a matter of proof, reckless conduct for somebody who is when you're using a car, okay, when it comes to driving? What separates reckless conduct from reckless conduct with a dangerous weapon? In one sentence.
It's the use of your motor vehicle in an attack.
In an attack?
In an attack or a threatened attack is what constitutes using that as a dangerous weapon. It does not make any sense. Vehicles aren't typically designed as weapons. And
so you're saying it has to be, maybe put another way, used in an aggressive manner? Would that satisfy the statute in your view?
I think that would work. So I've talked about State v. Jones. State v. York has a defendant driving right alongside the victim in the breakdown lane, not taking the opportunity to merge, and then pushing that victim's car into oncoming traffic. Now, both drivers got out afterwards, and York came up, started yelling profanities, started saying other things that led to a criminal threatening conviction. The law court said this is a road rage case. But there needs to be something that distinguishes those cases from, honestly, the exact same conduct, but where the driver is merely being reckless, is being...
So when you said in an attack, you said use of the vehicle in an attack. Are you talking about in a directive manner? In other words, that you're... I'm trying to... This was a real question when I said put it in one sentence.
Yeah.
What is it that separates the two? Attack seems... I'm not sure where that word comes from.
Well, it comes from the two sufficiency cases we have. it comes from the inherent language of use of a dangerous weapon. You can't really use something not designed as a weapon if you're not using it in some kind of attack.
Sounds like you're importing the notion of intent, though.
So
Or
I think-
purposefulness, at least, if that's not intent.
Right, so in big I, let's separate intent as it applies to the mens rea context and then just intent as it applies to the motivations of the defendant, what was going on in his head. Something that would distinguish just merely the reckless motor vehicle driver from someone who's used something as a
But
weapon.
you
But we
agree
all,
it
we
doesn't-
all agree that a motor vehicle can be a dangerous weapon. Yeah,
Right.
can we agree on that?
Yeah.
So we have the defendant here driving down the road excessively, basically saying, get out of my way, get out of my way. I'm coming at you. If you don't get out of my way, we're going to collide. Is that not sufficiently purposeful? Or
Well, so are you talking about the facts of this case or the facts
take your pick.
generally?
Take your pick.
So, if you look at not just State v. Jones, but State v. York, you can consider State v. Seymour. This was an instance where there's a heated altercation between the parties. The defendant then jumped in his car, chased down the other car, and from behind rammed into him at high speed and caused the car to skid sideways.
So does it have to be, I didn't mean to interrupt, but does it have to be contact in order to be qualified as used as a dangerous weapon?
No, it doesn't have to be.
Hence the case where you're sort of trying to push them off the road even if you don't actually
Right.
make contact.
Just right.
Isn't this really a question of fact? You're sort of asking us to canonize this as a matter of law, but I mean, the statute says in the manner of, use in the manner of. Isn't that really up to the jury to decide?
That's what, I did argue this to the jury. It can be up to the jury whether the defendant was trying to attack the other person or threaten an attack or use their vehicle as a dangerous weapon.
So in this case, there's video evidence, I think twice, your client's car collides with a police officer. So following up on Justice Douglas's question, given the standard of review we have to apply to a sufficiency challenge, why you would like us to say as a matter of law that does not qualify as use of a dangerous weapon?
Yes. And so, there wasn't sufficient evidence to convict him.
But wasn't there, I mean, when he was on the video, when he's on the New Meadows Road and goes at the Route 1 entrance ramp,
Yep.
he stops, the police cruiser's behind him, and then he flips around and comes nose to nose. He doesn't actually hit the cruiser, but the officer actually exclaims, he was trying to ram me. And certainly that is one interpretation of what happened. Isn't that enough? As a jury question. I'm not saying as a matter of law, but to create at least a jury question.
You also need the element of a substantial risk of serious bodily injury.
Isn't there
This
always
is-
substantial risk of serious bodily injury when cars collide?
Not
People
in
get
every
serious bodily injury even at low impact sometimes.
Not in every instance. In this case, the crash, or the collision you're talking about is a mere tap at the front of.
Well, I don't think there was a collision at the entrance from New Meadows. That was at the beginning of the chase. I don't think there was a collision. I think he just flipped around and came
Right.
close, nose to nose.
But you suggest that a threat of that type of conduct could constitute reckless
Sure,
conduct with a dangerous weapon.
So we need something to differentiate between the mere reckless motor vehicle driver who could do the exact same
And
thing.
we can agree with that, and that's why I started off with, tell me how to differentiate it.
Well, so I think you need to look at the context surrounding all of this. He was trying to escape from officers. He was at the top of the New Meadow Road. He's trying to turn around.
That's one interpretation. But I mean, looking at the video, I agree that that's a potential interpretation, but the officer thought he was trying to ram him. And isn't that a jury question as to whether that's what he was trying to do? And if he is trying to ram the officer, isn't that reckless conduct with a dangerous weapon?
Attempting to ram another vehicle if would likely qualify as using your vehicle as a dangerous weapon.
But you're
seems to
using
be some-
contact as the tipping point there. If we parse out the statute, use of a dangerous weapon is the use of an instrument which, in the manner it is used, is capable of producing death or serious bodily injury.
Right.
Doesn't he fall into the four corners of that parsed out definition? The manner it was used.
Yes, that's one of the issues. If you,
Doesn't require that the harm actually occur or that the injury occur.
right.
Just in the manner that it's used. And as we picture him careening down the road and people getting out of the way, capable of producing bodily injury. Isn't it
Right.
textbook?
We need something, though, to differentiate the use of the weapon from someone who's doing the exact same thing, but they're just texting on their phone, or they're otherwise acting really recklessly, really dangerously, creating a substantial risk of bodily injury, but not using their vehicle as a
Can
weapon.
You've not raised an error in the actual instruction that was given, correct?
Right.
So then, what you're trying to say then is that even though they were correctly instructed as to the elements, they could not have found that he used this as a dangerous weapon. I think that's, given that somebody thought he was trying to ram him, that's a little hard, isn't it?
Well, I don't think it's just up to the victim to say what was going on in the head of the defendant.
No, but I saw the
There needs to be
video.
greater context there.
Could we pivot to the grand jury issue
Yes.
for a moment? Do you agree that under our venue jurisprudence, the state can elect to prosecute a continuing crime in any county in which the continuing crime occurs? Under our venue jurisprudence, we'll start there.
Right. Yes, I do agree. to
Okay.
that.
Why would it not be the same for a grand jury territorial authority?
So a couple of reasons. One is the jurisdiction, Article 1, Section 7 places the jurisdiction regulation for grand juries in the hands of the legislature.
No, I
So-
understand it's a jurisdictional question, just in terms of, the statute says has to be indicted where the crime was committed. So for venue purposes, we have sort of this continuing offense jurisprudence. Why wouldn't we use that same standard to determine where the crime was committed for purposes of grand jury territorial authority?
I think you would be able to do that. The problem is these crimes were not continuing. So the Supreme Court states continuing crime has to be something inherent in the nature of the crime or something, and I'll just
I'm going to let you finish. I didn't cut you off.
inherent in the nature of the crime or something inherent on the face of the language of the statute. And that's not the case for reckless conduct and eluding. He was not committing eluding throughout the course of the chase.
Thank you. Attorney Hughes, we'd be happy to hear your argument.
Good afternoon, Madam Chief Justice, Justices of the Law Court. May it please the Court, once again, my name is Kristen Hughes. I'm an Assistant District Attorney in Cumberland County on behalf of the state of Maine today, the appellee. As to the first assignment of error, appellant is asking this court to reject its own precedent in State v. Seymour. Appellant in Seymour asked the court to do exactly what appellant here is asking this court to do, which is to read specific intent into the statute. That was soundly rejected by the court in Seymour and should be soundly rejected by this court as well. Furthermore, there was ample evidence that the defendant, to convict the defendant, and this court should not supplant its own judgment as to the facts of the case for that of the properly instructed jury in this matter. As to the second assignment of error, the grand jury had territorial authority over the defendant's conduct, but because both eluding and reckless conduct with a dangerous weapon require continuous intent. To the extent that the count charging aggravated criminal mischief was improperly included in the indictment, that does not mean the indictment is void ab initio. Indeed, such a construction ignores the...
I'm going to interrupt you. I see
Thank
the
you.
green light is on. I was really a little bit, I understand you don't want to incorporate a full-blown intent, but I'm going to ask you the same question I asked opposing counsel. Give me in one word or in one sentence how to differentiate reckless conduct with a dangerous weapon from reckless driving.
It is in the manner in which the car is used. It's written right into the jury
What
instructions.
does that mean?
And that's for the jury to decide, Your Honor.
They can decide anything they want, but the jury is told that without saying, and by the way, it has to be different than everyday reckless conduct. They're not given that contrast. They're just said, they're told it in a vacuum.
I disagree that they're told it in a vacuum. They're told it in the context of understanding what the terms recklessness mean, and the context of the facts presented to them at trial.
So eluding an officer, in this case, intentionally or knowingly attempt to elude by driving a motor vehicle at a reckless rate of speed that resulted in a high-speed chase. Is every eluding case also a reckless conduct with a dangerous weapon case? You're
No.
driving recklessly at a high rate of speed in a motor vehicle.
No, because again, there's
What
no...
makes it different?
There's no indication that there was any intent or any conduct that was putting anyone else at risk.
So there does need to be intent to put other people at risk.
I think there needs to be some evidence that other people on the roadway were at risk.
And you
Whether
don't
or
think
not-
other people on, does it matter then for an eluding charge? If the eluding charge is there were other people on the road, then it's also always ipso facto a reckless conduct?
Not ipso facto, but I think it would absolutely depend on the context in which that defendant was driving and eluding police officers.
So it's the dead of night, there's no one else on the road, they're going, the defendant is going really fast, that can be eluding, but not reckless. There's somebody else on the road, now it's reckless with a dangerous weapon.
No, I would disagree with that, Your Honor, and because if that person pulls off to the side of the road, they're not in any danger.
Well,
Of being chased by the
it needs
defendant.
to be a reckless rate of speed for the eluding.
Yes, for eluding, but just because someone is driving at a reckless rate of speed does not mean that they're using their car in a reckless manner.
Okay, so
And I
what
think that
means-
is the difference.
What makes them using it in a reckless manner?
Using it in a reckless manner would be putting other people at risk of serious bodily injury in the way that it's used. And that determination would be up to a jury in understanding all the facts of the case.
But, I mean, couldn't you argue, though, I mean, cars are extremely dangerous. We know that. So I'm concerned that we're sort of collapsing anytime you're driving recklessly, you're potentially creating a risk of death or serious bodily injury to other people on the road. So where is the line?
I think there absolutely is a line, and I think it would depend on...
I keep saying that, but I haven't
Yes.
really gotten the articulation of where that line is.
And I think it has to do with the context of where the person's driving, how fast they're going. Are other people moving out of the way? Is there any risk that the driver or the defendant could be ramming into other people
So
or
it's sort
pushing
of
people off the road?
recklessness plus? Is that how you would characterize it? There's got to be something more than just...
I think there needs to be more to indicate that other people were at risk on the road.
And by the
So-
way, you kept saying people were moving out of the way, but what they saw coming, this was at night, right? And what they saw coming were blue lights. Aren't they supposed to pull over?
Yes, absolutely. But that's not why that particular driver pulled over. The evidence at trial was that he pulled over to avoid a collision with the defendant. And so that's a distinction as well, that the defendant was driving in such a way that he nearly caused a collision with that motorist on Route 1. He nearly caused a collision with the officer getting onto Route 1. So I think looking at the entire universe of facts that the jury heard, the jury was well within its discretion to find there was sufficient evidence that he used that car as a dangerous weapon, even though he didn't cause any collisions up until the very end when he rammed a police cruiser head-on in that parking lot of the gas station.
At a very low rate of speed, though.
Yes, at a very low rate of speed, but
All going around the gas
Yes.
circle.
Well, I mean, we're trying to interpret the word use. And so like you take a frying pan and it's got one use, but if you use it to flat somebody on the side of the head, it's a dangerous weapon. So it's using it, you're weaponizing it. With a car, you're using it in a normal instance to get from point 1A to point B. Now, in this case, it's not just getting from point A to point B really fast or in a dangerous manner, but it's also ramming in or threatening to ram into policemen in an effort to evade them, which goes beyond trying to get from point A to point B. So in that respect, is it being used as a weapon?
I would suggest yes, and the jury agreed with you. And I think it's actually State v. York, where there were 2 counts of reckless conduct with a dangerous weapon. One was for hitting someone with the car door, and the other was for trying to run over someone. The jury found that defendant not guilty of the first and guilty of the second. And I think that is another distinction. There are lots of different ways that pieces of a car could be used as a dangerous weapon. The jury in that instance found that opening the door onto someone was not the use of a dangerous weapon, but trying to drive over someone would be.
I know you don't want to import wholesale the idea of intent, but doesn't the whole very idea of use, in other words, how you're using it, doesn't that in and of it's not a specific intent to cause the result or anything like that, but doesn't that import some element of, like I say, whether we call it intent or purposeful conduct, that you are using this vehicle? The very idea that you have to use the vehicle is something more than just recklessness, isn't it?
Perhaps it's more than recklessness as to...
I'm not saying you have to intend to cause bodily injury. I'm not saying that. But you do have to intend to use the vehicle, whether it's to scare somebody or to get your way, to use it, regardless of the risk to others.
Certainly, and I would suggest that that's true of all conduct that someone is being accused of criminal activity for. You have to, in some way, intend all of your actions to have the mens rea to be convicted of anything in a criminal context.
No, you're just talking voluntary.
Yeah, you're acting in a voluntary manner. So you're intending to act in that manner, but it doesn't mean you have the specific intent to cause a certain result.
But even if you don't have an intent to cause the result, doesn't the idea of use as a dangerous weapon say that you intend to use the vehicle in a manner that you should be aware would cause injury, serious injury? Even if you don't intend to cause that injury specifically.
I do think that all of the case law would suggest that there's something more than just driving your vehicle on the road at a high rate of speed that would be reckless conduct with a dangerous weapon.
Well, it's awareness of the risk. You're engaging in the conduct, and you're aware of the risk.
Agreed.
So if you're driving at over 100 miles an hour on the turnpike, you're being chased by an officer who's trying to arrest you for some reason, and it's raining or snowing and the conditions are awful, officer's car goes off the road and the officer's killed. Does that meet the definition here for reckless conduct with a dangerous weapon?
I think it would depend on the way that the defendant was driving. If he was trying to, move across lanes, trying to weave through traffic.
He's down the road, he's driving 100 miles an hour, conditions are snowy, and, the officer is a tenth of a mile behind him trying to catch up to him and goes off the road. Because it's so snowy and so fast trying to catch up to him at 100 miles an hour. I think that's the scenario that you were trying to posit. So
I think that would certainly be reckless conduct on the part of the defendant. It would certainly be eluding.
But it's not something we have to get into here because it's a sufficiency argument, and if there's evidence that he was trying to use it as a ram, that kind of says it's a weapon without having to probe what if he was just driving fast,
are you
right?
the only one who's allowed to give hypotheticals?
Well, it is sufficiency we're dealing with here, right?
Thank you, Justice Connors. Yes, I would agree.
So, in other
You
words,
pointed that out in the beginning.
I did.
even if we were to adopt the attack approach or the requirement that there be some aggressive behavior, your position is that the facts here could have been construed by the jury to meet that standard. Is that fair?
Certainly, yes, Your Honor. And I would suggest that the jury instructions to this jury, that nothing needs to change as to the jury instructions, that using it using the weapon as a dangerous weapon is something that a jury can use their common sense and common experience to understand and parse out in looking at the evidence. And in this case, there was ample evidence to suggest that he was using his car as a dangerous weapon.
Let me pivot to the grand jury issue. Is reckless conduct a continuing crime?
I would suggest yes, especially in this case.
And so is it your view that in determining whether something's a continuing offense, we don't have to decide as a matter of law that a particular statute is? We look at the facts of a particular case to decide whether it's continuing?
No, I think that the intent required in the statute itself indicates that the reckless conduct with a dangerous weapon is a continuing offense, because same with eluding, until the chase comes to its conclusion, or until the conduct comes to its conclusion, that the intent is required throughout that conduct.
So what if the reckless conduct with a dangerous weapon involved a firearm, and the defendant's in Saginaw County and is shooting the gun off in a reckless manner, and then drives to Cumberland County and does the same thing in a short period of time with the gun again? Would you charge that as two separate offenses in two counties, or you would charge that as one continuing offense?
In that hypothetical, Your Honor, I think it would be two distinct charges. However, if he were driving from Cumberland County into Saginaw County and was shooting at another car that was driving next to him, that would be continuing intent, and I believe that it would be appropriate to charge one count of reckless conduct in Cumberland County.
Is it sufficient that the eluding is essentially a continuing crime, even if the reckless conduct is not, for purposes of the jurisdiction in this case?
Honestly, I'm not exactly sure of the answer. I think eluding certainly is a continuing crime in this case. The reckless conduct with a dangerous weapon, I think there were specific instances that occurred wholly within Cumberland County. They also happened in Saginaw County as well. And so I think both of them are continuing intent offenses that support the
There's no
jurisdiction.
question if they were charged separately, they'd get joined for trial, is there?
There's no question that if they were charged separately, they would get joined for trial. I think, and that's exactly what happened here, that in Justice Cashman's decision in keeping this case together and ready for trial when she did. That was part of her determination, a judicial economy determination, that it doesn't make any sense to sever these cases, because that was part of the motion practice pre-trial. Counsel filed a motion to sever and transfer, and those were denied, in part relying on the rules discussing joinder and judicial economy.
What's the remedy for, let's assume we agree with defense counsel that the grand jury did not have jurisdiction to indict for the Cumberland County grand jury did not have jurisdiction to indict for, say, the reckless conduct with a dangerous weapon. What happens to the conviction?
If the court were to agree with that argument, I believe the court would have to vacate the conviction and send it back.
But if it's a jurisdictional question, aren't you then free to indict in Saginaw County?
Correct. And as far as I understand appellant's argument, the argument is that if any piece of the indictment is invalid, the entire indictment is invalid, which did not give the Unified Criminal Court jurisdiction over the entire case, which would then give the state a mulligan on the whole thing. And we could charge the entire case again, even the counts that he was acquitted of. And I would rely on State v. Moulton for that proposition. It does not violate double jeopardy if, on his argument, the entire indictment was invalid and deficient. That means it erases the entire procedure that happened in the Unified Criminal Docket, and the state would get a do-over on the entire thing, including the counts for which he was acquitted. If there are no further questions, I will rest on my brief.
There don't appear to be.
Thank you.
But that is a lovely place to start, counsel. Do you agree with that proposition, that if the grand jury did not have the appropriate jurisdiction to indict for at least one of the offenses, then the whole thing is defective and there's a do-over for all counts, including those that the defendant was acquitted of?
Yes, I agree.
So this would be a Pyrrhic victory for you.
Well,
Okay,
have
here's
to
my hypothetical. Somebody's on a
See, she's the only one who gets to ask hypotheticals.
Somebody's on a huge crime spree, and they go through 6 counties all in one night, continuously robbing banks. Bing, 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 bing. Where do you indict them?
you indict them in the county in which the crime was committed.
6 of them?
Correct.
6 different grand juries.
That's correct. Now, venue, under Rule 21 of the Maine Rules of Criminal Procedure, will then allow courts, even over the objection of the defendant, to transfer those after arraignment to a neighboring county. Presumably, you could combine most of those into one county.
How should the state have charged the reckless conduct here, in your view?
To do this appropriately, they would have had to indict with the Saginaw grand jury. That after indictment, they could have transferred this to Cumberland County.
But why do you pick only Saginaw? I mean, he's driving between counties.
They could, right, they could have done either and then transferred. But in this case, it was just indicted in Cumberland County.
I guess I'm not understanding. He's driving from Saginaw to Cumberland, back to Saginaw.
Yes.
You're saying they did indict in Cumberland,
Yes.
and you're saying they should have indicted in Saginaw?
If they wanted to have to present any evidence of Saginaw County conduct, they needed to indict that Saginaw County conduct.
But the statute doesn't talk about conduct. The grand jury territorial statute talks about where the crime was committed.
Right, right.
So where was this crime
Well,
committed?
The crime was, when it's committed in Saginaw County, it's committed in Saginaw County, and that's where
Can
the
it be
indictment
committed in
is.
2 counties, is my question.
So reckless conduct can't. Reckless conduct, just the nature of the crime, and the nature of the crime, the language of the statute, means it's discrete instances.
Well, so let's take the hypothetical of someone driving while repeatedly firing a gun, you know, boom, boom, boom in
Right.
Saginaw County, then into Cumberland County, more shots fired, all within short succession. You're saying those are each discrete incidents and could be charged separately as reckless conduct?
So they could be charged separately. They could also be combined for venue purposes for trial as one, in one county.
But your view is that the state would have to charge each of those
If they-
instances of shooting the gun separately?
Right, that's what 1255A indicates.
And you don't think you would object on double jeopardy grounds if that happened?
So,
Isn't that sort of like charging for each punch in a fight?
well, so there's the 100 rod rule, which should cover a lot of this. But no other exception would apply, and so you would be able to win some double jeopardy arguments on some of those grounds.
Thank you, counsel. I'm sure it will be no surprise for me to suggest that we will be taking the matter under advisement and issuing a written decision in due course. I also understand that for both of you, this is your first argument in front of this court, and as is our tradition, we would invite you to come back and take our greetings. And yes, Mr. McNamara, you can come too. And good afternoon, you can be seated. And the matter before the court is docket number Penobscot 24-436, U.S. Bank N.A. as trustee versus Richard Jewett et al., including Unifund CCR Partners. We are being recorded and broadcast on the web, both by audio and video. And if the council would identify yourselves by saying the name of the party you represent, together with your own name for the record, starting with the appellant.
Your Honor, my name is Stanley Greenberg. I represent Appellant Unifund CCR Partners.
Good afternoon, Your Honor. Attorney Carrie Folsom for the appellee, U.S. Bank National Association as trustee.
Okay.
I'll just keep it to that shortened version of the full long name.
Thank you. And counsel, Attorney Greenberg, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court, Chief Justice Stanfill and members of the law court. As I said, my name is Stanley Greenberg. I'm an attorney from Winthrop, Maine. And my client, as I said, is Unifund CCR Partners. Now, please forgive me if I refer to my notes for this opening statement. The last time I memorized anything was 32 years ago in my wedding for my vows. My opening remarks focus upon the relief requested by the appellant, which is for a vacation of the underlying Superior Court judgment of dismissal without prejudice, for a remand to the Superior Court for entry of a judgment for defendants, and for an evidentiary hearing to determine the amount owed to U.S. Bank, the appellee. If Pouchard and Duchesne were still the prevailing authorities, there would be no need for this evidentiary hearing, because the Superior Court's finding of a deficient notice of right to cure default would have resulted in a quote-unquote free house for the defendants. But Finch was decided after this case went to trial in October 2023, and the legal landscape has changed. Instead of a free house, defendants and my client have the benefit of claim preclusion arising from U.S. Bank's failure to assert a separate claim for the unaccelerated amounts due under the note. These amounts must be quantified by the Superior Court, especially because in this case, the promissory note itself transforms amounts due under the mortgage into amounts due under the note. And I cite the section of the note in my brief. If all the mortgage costs and all the amounts due under the note are barred by the Finch rule of claim preclusion, then all that would be left due will be the principal balance of the note itself, which as of mid-September 2025 is approximately $29,000. Should there be no determination of this balance due, U.S. Bank will be free to argue that its mortgage expenses and costs to date are not precluded from collection, thereby adding roughly $25,000 to the total. Should defendants be interested in a refinancing or a sale of the premises, this is a significant added cost that will have repercussions on the ability of my client to realize upon its judgment lien. Of course, holding such a hearing in the Superior Court only makes sense if the law court continues to support the Johnson-Pouchard proposition that the defendants no longer owe U.S. Bank the amounts precluded from collection by the Finch rule of decision. Consider what would happen if the Johnson-Pouchard rule is not upheld.
Attorney Greenberg, I see the green light's on.
Yes, Your
I
Honor.
just had a few questions for you. I'm trying to better understand your argument, where you're coming from here. You disagree, I believe, with the dismissal without prejudice. Do I understand you to be saying that?
That is correct, Your Honor.
And you are citing Finch, but Finch has some language in it that I think is instructive. They're quoting from some earlier cases, where it says, when this happens, when there's a defective notice of acceleration, I'm quoting, The parties are returned to the positions they occupied before the filing of the action, except for any claim as to an unaccelerated amount due that could have been litigated. And then, also from Finch, again quoting from earlier cases, a lender that cannot prove ownership of the note lacks standing, and a foreclosure action commenced by a lender that lacks standing is dismissed without prejudice. So, according to that language I've read from Finch, the court below did exactly what Finch tells it to do. Do you disagree with that?
Yes, I do, Your Honor, for a couple of reasons. Addressing the point about standing first, that was a jurisdictional issue, Your Honor. It wasn't a condition of non-satisfaction or a precondition. So, with standing being a jurisdictional issue, dismissal without prejudice is the proper disposition.
Okay, so dismiss without prejudice if there's no standing. You're okay with that?
That part is correct.
Okay.
But that's not what's going on in this case. It's not a question of
Okay,
jurisdiction.
I thought I read in the case here that the judge said dismissed without prejudice.
Yes, but he wasn't talking about standing. He's talking about failure to satisfy the precondition of 6111. Now, with respect to the quoted language, as I go on at some length in my brief, the language of Finch is taken, paraphrased, if you will, from the Fannie Mae versus Thompson case. Now, in Fannie Mae versus Thompson, the court used this language. The parties are placed back into the positions held before lawsuit. In Finch, that became the parties are returned to the positions occupied before filing.
And then they added that there's claim preclusion because if an action could have been brought on the note in that initial action, but it wasn't,
Yes.
by claim preclusion, it's cut off there, and that's exactly what the court did below down here.
Well, cutting to the chase, Your Honor, dismissal without prejudice is not a final judgment. It means that there will be no preclusion of anything, whether it be because of non-satisfaction of the precondition or because of the failure to plead the unaccelerated amounts due under the note.
I'm with you so far. So I agree that a dismissal without prejudice doesn't resolve anything substantive about the case. But Finch put that rider onto it, said if there's a problem with notice, it's dismissed, and for some reason there's no standing, then claim preclusion is going to kick in, although that doesn't happen until the subsequent foreclosure action is brought.
Well, Finch didn't go that far, Your Honor, to say nothing happens until a subsequent
But
foreclosure.
isn't that just general jurisprudence? In other words, that res judicata, claim preclusion, those are affirmative defenses that are asserted and litigated in any subsequent action, as opposed to in the original action. When I enter a judgment in a case, I don't say, and by the way, in the future, you would be precluded from X, Y, and Z, but not A, B, and C. I mean, that A is an affirmative defense which can be waived, and if not asserted, and B is always litigated in the subsequent matter, is it not?
Well, it certainly can be, Your Honor, but it also means that, as per Pouchard and Johnson, when claim preclusion was applied in those cases via res judicata, it meant that the defendants no longer owed those amounts to the foreclosing bank.
And in Finch, we've said that's not the case.
No, Finch made no...
Well, I mean, we didn't give we said the claim wasn't accelerated, and therefore they are returned.
So in this case, if this case were decided differently from Finch, there would be an obvious conflict. This case is on all fours with the fact pattern of Finch, except for the pre-existing judgment. There, in Finch, they said that the failure to satisfy the precondition resulted in a judgment for defendants. And the rule of decision makes that mean that there is no impediment to further foreclosure, subject to preclusion of those amounts that could have been litigated in the first action but were not.
So isn't the problem here, doesn't it lie in the final part of the judgment, if there's a problem from your perspective? The final part of the judgment is, let's see, what page is that on? And it says the conditions include not to collect certain things. I'm going to find it, but
Late fees and interest, Your Honor?
Right, and that the problem should be that essentially that needs to be, where it says if the plaintiff files a subsequent action, the plaintiff may not recover any costs or attorney's fees related to this if you add it in, or amounts already past due that could have been litigated. Does that take care of it? In other words, in accordance with Finch?
No, because what the Superior Court said was this issue doesn't arise unless there is a future subsequent foreclosure action.
Correct.
And in this case, the appellee has admitted that that's a likely prospect that there will be none. So that in the interim, after judgment in this case, the Jewetts and secondarily my client are faced with the prospect that the bank will claim much more than would otherwise be determined to be the case if there is this evidentiary hearing I'm talking about. The bank will say, yes, we are precluded from collecting amounts that were not pled in the prior action that we could have pled, but we do get to claim all these mortgage costs and expenses that have accrued for many, many years. Now, that is not true in this case because of the existence of a promissory note that converts those mortgage expenses into amounts due under the note. So to be more precise, Your Honor, a dismissal without prejudice does not grant the Jewetts and my client the protection of claim preclusion whatsoever. That puts it in direct conflict with Finch, and my brief tries to show the court how the Finch decision should be interpreted to mean that a judgment for defendants is not with prejudice with respect to the unsatisfied precondition, but is preclusive as to those amounts due under the note.
You said that, though, that you think it should be vacated, remanded, it should have a judgment for the defendants, remanded for an evidentiary hearing on the amount owed. Whose burden? I mean, here we had a hearing, and the judge found that the plaintiff failed to prove the amount owed as of the date of default. And isn't that the judgment, that they failed to prove how much was owed? I mean, and now you want to change that and have them try it again? I don't even understand that.
Well, below, Your Honor, there was no finding of the amount.
Well, the judge excluded the exhibits that as unreliable that would
Yes, he did.
supported that.
But he didn't decide the ultimate issue of fact of whether the plaintiff had proved his case on the element of the amount of damages.
Correct.
So the only issue with respect to the elements of proof of foreclosure that the justice below found was lack of compliance with 6111. And because that was the primary holding, he dismissed the case. But he did it with prejudice, which undermined the holdings of Finch.
No, he did it without prejudice.
You mean?
I'm sorry, Your Honor?
He did it without prejudice. You said he dismissed it with prejudice.
Well, I'm sorry.
Okay, just want to make sure on the same basis.
Without prejudice.
And if you could explain something, you had in an earlier answer, I think I heard you say, when the judge dismissed this without prejudice, my clients didn't get the benefit of claim preclusion. Is that what you said? Did I hear that wrong?
Correct.
What benefit from claim preclusion would your client get?
Well, we're talking about a property that has a certain value. If there's claim preclusion as to amounts that...
The unaccelerated amounts, yeah.
That has the effect of lowering the amount of the plaintiff's claim. To the extent that the claim is lowered, that leaves more equity for the Jewetts and more equity upon which my client's lien will
Oh, I
have
see. So
something
you're second
attached
in
to.
line. There's a smaller pool for the folks who are second in line. And that's why you're here today.
Exactly. That is the interest that my client has
Gotcha.
in pursuing this appeal. Now I have just a few seconds left. Is there a further question?
Did I hear you say the equity will increase?
Yes.
So your client is advantaged.
Yes. If the amount due to the bank is decreased
And
by virtue of preclusion.
and it is. Obviously, another claim has to be brought, but But it is precluded, isn't it?
It's not obviously, Your Honor. Pouchard, Johnson say it's not, you don't have to wait for the next action. The defendants do not owe that money now.
I see.
And the law court should endorse that. Otherwise, the Jewetts are left in limbo for perhaps years. Sure, they could bring an action for declaratory judgment on this point.
Well, can't we just say that judgment should be modified to reflect the holding of Finch that the unaccelerated amounts are precluded?
That would be satisfactory, but not as an amendment of what the court did below, not as a condition of the dismissal. It's a separate aspect altogether.
Thank you.
I have leave to ask one
Go
more
ahead.
question. But that's a rule of law. The judge said it's dismissed without prejudice, and Finch says that claims for the unaccelerated amounts that were not pled in the earlier matter are barred. Why does the court have to say that fact when it's already a rule of law? Any subsequent action that would apply?
Well, if I may answer?
Yeah, please.
You may.
The law court may say a dismissal without prejudice in these circumstances still does not abate or affect the rule of preclusion announced in Finch. That would be one thing. But strictly speaking, if it's a dismissal without prejudice, there's no final judgment, there's no preclusion.
Thank you.
Thank you.
Attorney Folsom.
Good afternoon, Madam Chief Justice, justices of this court, may it please the court. A couple of things U.S. Bank wanted to clarify based on statements in Mr. Greenberg's reply brief. He stated that we're seeking to change the trial court's judgment. We are not. We didn't appeal. We're satisfied with the judgment as issued. And also, Mr. Greenberg's arguments presuppose that if a foreclosure is ever brought again, we will ignore Finch, we will ignore the existing judgment, and claim things that we're not entitled to, and that's not correct, especially in the existing order from the trial court on page 48 and 49 of the appendix. He straight up says, no award of attorney's fees. So if you were to call and request a quote of how much is due on Mr. and Mrs. Jewett's loan regarding attorney's fees and costs, it would be zero, despite what's, and that's never going to change unless we file a new foreclosure. So I just wanted to sort of clarify and bring that back around. U.S. Bank believes there's two primary issues at play here, whether Finch and the trial court's disposition are in concert and are correct, and whether Mr. Greenberg, as counsel for a party that's not a defendant, not on the note, and not on the mortgage, can request a judgment for a different party. He says he's seeking judgment in favor of the defendant. I think we can dispense with the Finch argument quite quickly. Finch is very clear. It mentions what things cannot be recovered, and as counsel for plaintiffs in many, many trials, I know I am bound by that if we ever go forward again and file a new suit against the Jewetts. Especially in the trial court, he was very specific about what we cannot recover. That's not going to disappear or go away. We will always be bound by that if we foreclose on the Jewetts' property anew. And I think the most important part of the Finch decision is at the bottom of page, paragraph.
Can I just follow up on what you just said, since
Sure.
I see the green light is on? You would agree that regardless of the language then of the trial court in this case, should there be a subsequent action, the U.S. Bank would be precluded from recovering the unaccelerated amount at that point, that had accrued at that point, even though it's not specifically mentioned,
Well,
i.e. in accordance with Finch?
Finch states the unaccelerated amount, but it also, the most important sentence, it's toward the bottom of paragraph 49 on page 35 of this court's printed decision. It would allow the court, a future trial court, to tailor the consequence, potentially including sanctions, to the circumstances of the case. So what the trial judge did here was say no attorney's fees. He said certain numbers of payments cannot be recovered, certain other expenses and late charges cannot be recovered. He took Finch, that allowable section that says tailored it to the factors of the case, and that's what he's already precluded us ever, whether it's my firm, somebody else's firm, from ever attempting to foreclose again. That's going to be precluded.
And
We
that's
can't
a
recover that.
done
We're not
deal.
going to seek it.
And that's a done deal, that you could never recover it again. And Finch does provide that little wiggle room to say to the judge, if you're a little disturbed about the way things went down, you can go ahead and augment this rule of law, which is that they can't recover those matters claim preclusion, but also you're going to get dinged over here too.
We didn't necessarily agree with everything that the trial court did or everything that was recited in the trial court's judgment, but we did not appeal it. It's U.S. Bank's position that that order is associated with the Jewett, with their note and mortgage, and if a foreclosure is filed 2 months, 2 decades, however long ago, that's never going to change. That will always be applicable. But
So
I
I'm
think
still a little confused on whether you're agreeing that the amounts, unaccelerated amounts, that could have been claimed in this action would indeed be precluded, even though not specified.
well, the trial court was very specific about what he didn't call those
And did not include the
unaccelerated.
unaccelerated amounts.
I think that would be a matter for the future trial court, should there ever be one, to decide.
Well, that's the problem, isn't it? I mean, what Mr. Greenberg is arguing is that Finch makes it clear that the unaccelerated amounts of the claim must be precluded. Maybe the whole claim as a sanction, if you look at paragraph 49, if that were warranted. That's not what happened here, so I'm not suggesting it should be, but that at least the unaccelerated amounts would be precluded. And it sounds like you're not necessarily agreeing with that.
Well, it's not entirely clear what unaccelerated amounts.
Oh, we know we don't know what that amount is, but
Do you agree with the concept?
Yes, we
Okay,
do.
all right.
That should another foreclosure ever be filed, that carve-out of amounts that might have been due or might have been collected is off the table.
And even though you don't know what that is today, isn't that readily ascertainable?
Not necessarily,
Why not?
because we don't know when foreclosure is going to occur. If the bank makes the business decision that it's not worth pursuing a foreclosure at all, there may never be a foreclosure, or if they determine that the equity in the property is not significant enough such that they want to charge off the loan, there's no way to know.
But don't the unaccelerated amounts have a finite end, don't they? The date that the judgment was entered.
Yes, that you can calculate
So you
that
could
number.
calculate that number as of that date. That's the
Yes.
unaccelerated amount.
That could be calculated, but the Finch decision does leave some wiggle room to the trial court as to what it considers to be unaccelerated amount, or in this case, the judge didn't use the word unaccelerated. He specified a certain number of payments, late charges, expenses, and all attorney's
So you
fees are
seem to
off
be
the table.
highlighting the problem that Mr. Greenberg is concerned about, that the Finch decision actually doesn't make clear what would be precluded, is what you're saying.
I see Mr. Greenberg's concern that we won't forego anything. The Finch case allows the trial court to tailor the relief to the circumstances before it. And if the unaccelerated payments, as well as the payments that were subtracted out by the trial judge, that's up to the discretion of the trial judge. I know in the Moulton matter, the discrepancy was fairly slight compared to the overall mortgage balance. And similarly, under Finch, the trial court, if that ever comes back around, will have the discretion to say, well, yes, the unaccelerated and the other, one or both.
All right, let me just, it sounded for a second there like you were arguing Mr. Greenberg's point, which I don't think you intended to do. I mean, I think if I can understand what Justice Douglas is getting at, is the bank knows all the amounts that would have been due as of the date of the judgment. They could go back and they have their numbers people calculate that figure. And we call that figure, ABC. They could do that today, couldn't they?
Yes,
Okay.
yes, they could.
So
That's a discrete number.
That's a finite figure, so then we come down the road to a subsequent action brought on the foreclosure, and maybe the remainder of the note, and that figure would be not recoverable, but everything occurring after that date would be.
Correct.
Okay,
Correct.
all right. I thought I heard you arguing something to the contrary. Maybe I misheard you.
Well, the trial court judgment was very specific, and if and when we ever get back into court, Finch remains the controlling law, as well as the trial court's existing judgment. That would be determinative of what the bank was able to collect.
Right.
Just because we go back later and, as long as Finch is still controlling law, that
What would be the harm, in your view, then, in making explicit in the judgment the rule of Finch in this case?
For whatever reason, the judge decided to specifically list some items that he wants curtailed. Attorney's fees off the table, a certain span of payments, and additional charges. He was very specific. He didn't also add unaccelerated payments, but Finch is also the controlling law. So when a new trial court looks at this, that will be up to that trial court to determine what that number is.
You don't contend that there'd be anything erroneous about including unaccelerated payments in the judgment, do you? I understand that's what the
As being
court-
precluded.
Yeah, if the
sorry,
judge
could
has
you-
said,
could you repeat that?
dismissing if the judge had written, we dismiss the matter without prejudice because there's no standing, under the rule of Finch, any unaccelerated amounts due as of this date are not recoverable. And in addition, I'm going to oppose the additional sanctions. I think what we're asking is there any harm in that? Would anything be wrong about that?
No, I don't think there's any harm in that. U.S. Bank is fully aware that Finch dictates the disposition of the case, and the trial judge also had conditions regarding the disposition of the case, and when a new foreclosure is commenced, those items will be controlling on what plaintiff is able to seek.
And
Right.
what might plaintiff be able to seek at that point, given Finch's controlling and given what the trial court has issued as its order?
Whatever has accrued that's not barred by those things. Obviously, a brand new foreclosure, there'd be new attorney's fees to start, and whatever other expenses weren't explicitly stricken out by the trial court and disallowed under Finch.
And in
Whatever's
this case,
remaining.
since it was a 1999 note and mortgage, there may not really be a lot left, but had it been a 2010 note and mortgage, we might be in a very different position. In other words, that if some was precluded, there may still be a pretty substantial amount that wouldn't be.
Correct. It's an older loan. It's nearing maturity. There is still a balance remaining. But I would like to direct the court's attention to the other piece of this situation that I think is important. Mr. Greenberg is asserting defenses which belong entirely to the defendants. Section 6321 of Title 14 states that even if a junior lien is missed, the judgment is still valid. So that would lead one to the opinion that parties in interest, junior parties in interest, are not necessarily required in order to calculate the amount that's due on the mortgage. So
But we've said that a party in interest under 14 MRS 6321 has the right to defend against the foreclosure action and independently are entitled to litigate the validity of the mortgage, right?
It's a very narrow construction. 6321 says failure to join any party does not invalidate the action nor any subsequent proceedings as to those joined, which contemplates that if a valid judgment can occur without a missing party, such as Mr. Greenberg's client, being involved, then Mr. Greenberg's client being involved in the trial court is not necessary to the determination of
Have you
how much
waived
is
any
owed.
objection to the extent of their involvement by essentially agreeing to it in the trial court?
All that I agreed to in the trial court is that Mr. Greenberg does not have to sit and not question witnesses, not examine witnesses.
Well, he participated fully.
Participating fully. The Grossi case is specific. It states that a party in interest is involved pursuant to 14 MRS 6321, but it's limited to priority and challenges to the validity of the mortgage. Mr. Greenberg has not contended, nor his client has not contended that the mortgage is invalid, that there was fraud or duress or anything like that, and he has not contended that he is senior in priority. So it's U.S. Bank's position that his ability to assert defenses that are not his own is improper. He does not have standing to challenge the debt. As a junior lien holder, his client's interest is limited to the equity of redemption.
Are we
in the
talking about
property.
stuff that's going to happen in the future or stuff that should have happened previously?
I apologize, I didn't hear
Are
the
we
first
talking
part.
about things that are going to happen in the future or things that should have happened already?
I thought you were talking about he really can't challenge the judgment in this case on appeal because of his rights are limited under
The judgment
statute.
debt.
Okay,
Yes,
so you're talking about
correct.
what's happened in the past.
Yes, correct, correct.
How about a subsequent foreclosure action?
He'll be able to participate
Okay.
at trial.
All right.
He doesn't have to not question witnesses or challenge exhibits.
Okay.
But the defenses that he's raising, seeking a judgment for defendant, is not his, it's not his defense to raise.
There don't appear to be additional questions. Thank you.
Thank you, Your Honor.
And Attorney Greenberg, I believe you reserved 1 minute for rebuttal.
Judgment. If this judgment is modified by the law court, either by vacating and remanding or by amending it by way of a further clause in the judgment, that will be the date of judgment when the Superior Court does it, down the road. The final entry of judgment hasn't yet occurred unless the appeal is denied. And it will be at that point that these amounts will be calculated, as of that date, but not as of the date in August of 2024. Now, as to the standing of my client, 6321 makes my client a party in interest. We're a necessary party. While it's true the case can proceed if we're not named, we're a necessary party because we're a party in interest. And it would be odd indeed if a party in interest, a necessary party to the case, were not allowed to raise defenses. And the defenses that we raise are to the foreclosure itself, and especially where the trial court is required to find that the elements of 6111 have been satisfied in order to issue the judgment. It's entirely proper for my client to raise the questions about it.
Thank you, counsel.
Thank you.
Thank you for your arguments here today. We will, of course, issue a written decision in due course. Somehow, Ms. Folsom, it's my understanding that you've never appeared in front of this court before, despite the fact that you've appeared in front of me for many, many, many years. I hate to say how many. But as is the tradition of this court, we would ask that counsel come back and take the greetings. And with that, we will be in recess for the day.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting in the law court in Hennessy Park, give their attendance here at 9:50 a.m. tomorrow morning. This court now stands adjourned. God save the state of Maine and this honorable court.